Ladies and gentlemen, thank you for standing by. Welcome to the BIA Knowledge Leadership Series webinar. During the presentation, all participants will be in a listen-only mode. If you would like to ask a question during the presentation, please use the chat feature located in the lower left corner of your screen. If you need to reach an operator at any time, please press *0. As a reminder, this conference is being recorded Thursday, July 16, 2015. I would now like to turn the conference over to Robin Thompson. Please go ahead.
Welcome, everybody, to our July Knowledge Leadership Series webinar, where we'll be talking about the role of the paralegal in eDiscovery. Before we begin, just a quick reminder to send questions for the speaker through the chat window, and please do us a favor and answer the brief survey as you exit today's program, as the curriculum for our series of webinars is planned directly from your feedback. It is my privilege and honor to introduce our guest speaker today. Linda Carrette is a 30-year seasoned legal professional working throughout the state of Texas. She is a member of the governing and advisory boards of the Center for Advanced Legal Studies since 1989, where she teaches legal research and writing. Over the last decade, she has focused on high-level training, assisting teams with best practices in eDiscovery, providing consulting on ESI processing, preservation, collection, and legal hold strategies. She has a BA in business management. She also has her MBA in addition to several industry certifications, including being only one of 93 others who has achieved the status of board-certified civil trial law paralegal by the Texas Board of Legal Specialization. She is a frequent author and speaker, and it is our privilege and honor to have you with us here today, Linda, and I turn the program over to you.
Thanks, Robin. Today we're discussing the role of the paralegal in the world of eDiscovery. To fully grasp this, it's important that we explore and define the 5 critical pieces of the field of eDiscovery. First, I'll present a rather broad overview of a few of the federal rules that address eDiscovery and discovery in general. Second, I'll touch on a few of the ethical considerations in eDiscovery. Third, we'll address the litigation hold, including purpose, content, and implementation. Next, we'll mention some of the factors to consider when selecting an eDiscovery vendor, should that be a need, requirement, or an option for you. And then lastly, we'll talk a little while regarding how paralegals effectively manage eDiscovery and some of the steps and activities that are involved in this new project management for the legal field. First, just to make sure that we're all at the same level, I want to make sure everyone today understands what we talk about when we mention digital forensics. It is, simply put, the preservation, identification, recovery, authentication, extraction, documentation, investigation, analysis, and interpretation of electronically stored information, or what we'll call ESI. That's a mouthful, right? Along those same lines, when we refer to ESI, we're referring to any information created, manipulated, communicated, stored, and best utilized in a digital form. So exactly what types of information are we talking about when we refer to the typical ESI? Well, until the last few years, these are a few of the typical sources of ESI that we encountered. Mobile phones, digital cameras, flash memory cards, USB drives, CDs, DVDs, backups, and any type of voicemail or an audio recording, compared with the picture of ESI today. Today we've added a wealth of sources, the most recent of which you probably see would be that new wearable device called the iWatch. Now let's take a look at the rules governing eDiscovery. As I mentioned, this is a relatively broad overview, probably a presentation in itself. The thing to keep in mind today is that there will be amendments to the Federal Rules 26B1, 26B2, and then Rules 30, 31, and 33. Rule 26B1 addresses what is discoverable. Note again that this language, effective December 2015, adding the language that evidence must not only be relevant but proportional to the needs of the case. That language will be added to Rule 26B1, moving it from 26B2. Doesn't seem like a big deal. However, the goal in relocating this is to require its consideration by parties who are pursuing discovery and costs, and also through the courts that are trying to resolve discovery disputes. The language is being relocated because it was often overlooked by the parties. However, some people felt proportionality would become a new limit favoring defendants. So to avoid this, the Rules Committee noted that the burden of proving proportionality is not placed on the party seeking discovery, and that the amendment doesn't authorize a boilerplate objection that discovery is not proportional. So any objection to that will go away. So just watch for that amendment. Rule 26F3C addresses a conference of the parties, and we're going to talk about the paralegal's role in that later on in the presentation. Often a conference of the parties will result in an agreement regarding the production of ESI. And these are just a few of the topics that you might typically see in such an agreement. All of these items are critical in addressing ESI. And these are just typical considerations when you go to process ESI. On to Rule 34. 34A requires that, if necessary, a responding party must translate the information it produces into a reasonably usable form. On occasion, the responding party may need to provide some reasonable amount of technical support. Surprising, right? If the responding party maintains the information it is producing in a way that makes it searchable by electronic means, the information should not be produced in a form that will remove or significantly degrade this feature. Note the 2006 amendment to Rule 34A1. Parties aren't authorized to test or sample. They are permitted. Inspection or testing of certain types of ESI can raise some issues of confidentiality and privacy. The language stored in any medium only provided for future developments in computer technology as it advanced. There are going to be a few amendments to this rule as well. The key here is normal course of business. It prevents parties from either deliberate or inadvertent production that can complicate ESI and increase costs. And then here, note again the term permits, not require. And also keep in mind that professional courtesy with regard to the rules goes a long way, and you should probably do unto others, thus it come back to bite you when it's your turn to receive eDiscovery. The meet and confer will establish the protocol should either party be dissatisfied with the request or the form of an electronic production. And keep in mind that you may inevitably deal with some legacy data. And I'm sure there are many versions of legacy data. The one that comes to mind is Lotus Notes, which I encountered recently. Also keep in mind, today's state-of-the-art form of ESI will probably be 2030's legacy data. Also, ESI need only be produced in one form. I see this all the time. A party is not entitled to 3 separate different load files of the same data. Now, moving on to ethics, ABA Model Rule 1.1 requires the effective performance in eDiscovery. Lawyers can no longer bury their heads in the sand regarding eData and the trails that it leaves behind. The ABA made it abundantly clear that lawyers must keep up with technology when it amended Comment 8 to Model Rule 1.1. Model Rule 3.4 addresses an attorney obstructing another party or his counsel in accessing evidence, including eDiscovery, or failing to make a diligent search or a determination as to whether relevant electronic data exists. And then Model Rule 5.3 goes to ethical obligations of non-lawyers, such as paralegals. We have the same ethical duties and the level of professional conduct as attorneys, particularly with eDiscovery. Rule 26G makes it clear that the signing of a discovery response does imply that the attorney has made a reasonable inquiry into the facts of the case, and that includes the existence of and a subsequent search for eDiscovery. S2 versus Micron is a prime example of how the court will analyze and punish attorneys who do not adhere to Rule 26G. In this case, the court ordered the plaintiff, S2, to divulge the search strategy used to produce documents after concluding that plaintiff's counsel had not met its obligations under Rule 26G. The court determined that it could not analyze whether plaintiff's supposed search and the production of documents was a complete and correct disclosure of requested discovery because, first, the attorney delegated the entire gathering of documents to his client. Second, the attorney had no idea what protocol his client followed to locate the responsive documents and, in fact, was unsure of the manner and the form the data was produced. And third, the attorney was completely unaware that his client had separated emails from all of their attachments. The court concluded it was proper to compel S2 to provide its search strategies for identifying responsive documents, including actions taken and the role of S2's counsel in assisting in the production process. A favorite eDiscovery enforcement tool of the federal bench is, in fact, Rule 26G, which judges use as a stick to deal with eDiscovery abuses. Keep in mind that there's a long-standing history of sanctions being imposed on attorneys who fail to comply with eDiscovery requests. Model Rule 1.6 addresses the inadvertent disclosure of confidential material, and Model Rule 4.4 discusses how to rectify the inadvertent disclosure of confidential material. And we're now talking about confidentiality, by the way. The inadvertent disclosure of eData, however, does not mean that you waive privilege. You must take steps to rectify the error immediately and notify opposing counsel of the inadvertent disclosure. New technology like cloud computing makes tasks like file sharing pretty quick and easy, but you have to consider client confidentiality and data security. So far, 17 states have weighed in on the question of how to use cloud computing within the confines of ethical rules. They primarily focus on balancing risks and benefits while ensuring that client files remain safe and secure. Last point on ethics, technological incompetence isn't just unethical, it can make you look foolish and also impair an attorney's effectiveness in the representation of a client. So now we're going to move on to the litigation hold. Many of you might be familiar with litigation holds or lit hold or legal hold, although maybe you haven't participated in the drafting and implementation of one. Basically, a lit hold is a process which an organization uses to preserve all forms of relevant information when litigation is reasonably anticipated. There are three major components to the litigation hold: notification to custodians and other relevant personnel, ongoing preservation, and creating a repository for the documents that are under hold. Although the litigation hold itself is important, alone it is not sufficient. The purpose of the lit hold is to prevent the destruction of evidence, and the lit hold must be enforced. Once the hold notice has been issued, the company must suspend any document retention policies to prevent discarding data, and they must notify employees to immediately refrain from deleting any emails and all other electronic data. So, how do you put together an effective litigation hold? These are the steps to take in beginning the litigation hold process. And I won't read all of these, they're self-explanatory. I'll just give you a second to glance at them. What type of language should the litigation hold contain? These are some typical items that should be included in an effective litigation hold. Obviously, and at the top front center of the document, include the language privileged and confidential, attorney-client privilege, and attorney work product. You have to keep in mind that the people you're dealing with, custodians, don't understand the litigation process. So you have to kind of give them a map and spell it out for them. This might be a little difficult to see, but this is page 1 of an actual litigation hold. You can see a few of the topics that we just discussed. They're included, and they're pretty short and sweet. Most of them are generic in nature. This one happens to be 3+1 pages. This is page 2. And you'll note what I call page 4. Actually, this is titled the Document Review Response Form. The custodian will indicate that he's performed a search of all documents, including e-data in his possession or control, identifying whether the documents are electronic, agreeing that no documents in any way relevant will be destroyed, and returning the form to the legal department or outside counsel that is handling the hold. The center of the page there will basically have a spot for them to check, and by signing it, they're swearing that they either have documents, have searched, and have found no documents. And there's also a spot on there here on the lines below for him to indicate whether he believes that someone else may have the information that we're looking for in the event that we've possibly missed a vital custodian. Litigation holds must be signed by counsel and given the same weight as a legal opinion. The lit hold must be overseen by the attorney, but in fact it can and should be managed and monitored by a paralegal, including identifying and meeting with custodians and acting with in-house counsel and the IT department. So, how do we assist with this duty to preserve? What do we do? Well, here's some considerations in the duty to preserve. It's not enough to simply issue a litigation hold or reiterate the retention policy. Attorneys have to ensure that proactive steps are being taken to fulfill the preservation and the lit hold. This may mean reissuance of the lit hold periodically, and it may also mean that attorneys should test whether the hold is in fact being enforced. Litigation or legal holds should also contemplate backup tapes or systems, as well as all active data sources. Here are a few additional steps in the duty to preserve. There's a substantial amount of recent case law also which demonstrates the risk of businesses that fail to take steps to ensure preservation after the issuance of a hold. These cases serve as a warning that a written notice alone may be insufficient where an organization fails to take any further steps to ensure compliance with the hold and evidence is subsequently either lost or destroyed. In addition, the amendment of Rule 37E, which is likely to have the most impact on eDiscovery, will seek to impose a uniform standard as to the remedies available to a court when ESI is not properly preserved. And this is applicable when 3 criteria are met. And again, this is an amendment to Rule 37E. First, ESI is lost that should have been preserved in anticipation of litigation and was not. Second, because of a failure to take reasonable steps by the entity. And third, the loss can't be remedied by additional discovery designed to replace or restore the ESI. In other words, once it's gone, it's not recoverable ever. If all 3 parts are established, should a court find that the impacted party is prejudiced, it can determine a remedy no greater than necessary to cure the prejudice. There are 8 steps to a defensible legal hold. First, identify when the preservation obligation began. Legal hold action should be based on a formal preservation plan. Determining what ESI should be preserved, legal, IT, and the other stakeholders should always meet to identify custodians and possible repositories. Designating a technical authority, this should always be someone from the IT department who can serve as a point of contact and also serve as a 30B6 witness as to technological processes. Communication should be clear, concise, and ensure the suspension of any auto-purge or routine destruction practices. You need to track compliance, verify the custodian's receipt of the hold, obtain their acknowledgement, and then also track repositories. Documenting the employee's compliance with the hold should include the date of the hold, the scope of information requested, a master list of custodians and the systems involved, and then actively monitoring compliance. This would include periodically reviewing the hold to determine if it needs to be reissued as a reminder or perhaps modified to include new data that needs to be preserved. And then, of course, last, the release of the hold after the matter is over. This is a suggested checklist for you to use in the drafting and implementation of a legal hold. And again, I won't read this to you. Hopefully the slide presentation will be provided to you, and you can read this at your leisure. And these are just a few remaining steps in the same thing, how to go about drafting and implementing a legal hold so that the crucial steps are followed and nothing is left out. The last step here is really helpful if you're maintaining a chart or a list of your custodians and possible sources of information. You can kind of cross that off your list as you receive their written acknowledgments of the legal hold letter. Okay, so you've determined you need to delegate your project based on scope. How do you choose an eDiscovery partner? Well, first, you need to make sure to hire someone who has experience working on high-volume discovery matters. Don't hire a forensic investigator who hasn't testified or who has absolutely no experience in civil litigation. The vendor's experience should be relevant, tested, and defensible. Find out who is actually doing the work. Vendors outsourcing to each other is completely typical, but it's only okay when both parties have an established and transparent partnership and the client, that's you, are a party to that decision. When it comes to eDiscovery, obviously one size does not fit all. You need to find a vendor that's a trusted advisor who's willing to trade short-term profit for long-term profitability. Keeping in mind that more expensive is not better. Experience tells us that 80% of collected data can sometimes be culled out by virtue of it being deduped, irrelevant, or outside a designated time frame. So do your homework before choosing a partner and make sure that there's a bid that matches your needs. Building relationships is important. A partner who has the right level of experience can deliver reliable advice, perform tasks within your budget. Both of those things form the relationship that will save you dollars and time down the road. And then lastly, develop metrics for your project and determine oversight procedures at the onset of your relationship with your eDiscovery partner. So this would be your wish list of the ideal eDiscovery partner. A wide range of specialists, breadth of knowledge, practical approaches that have been proven successful, tested tools, insight and commitment. I say insight. Sometimes your eDiscovery partner may give you ideas and suggestions that you haven't thought about, and serve as a trusted advisor, keeping in mind that you deal with somebody reputable who's going to respect the client confidentiality. All of these characteristics in an eDiscovery partner will serve you well by helping your team enhance your internal eDiscovery processes. Careful vendor selection is one of the keys to maximizing efficiencies and minimizing your eDiscovery costs. There are many eDiscovery providers currently in the market, and they provide a variety of technologies, services, and methodologies. These are just a small sampling of some of the services they provide. Some of these things, obviously, you may think are typical. Some of them you may think, wow, I didn't know a vendor would do that. All of the vendors out in the marketplace won't offer every one of these services. Many do partner with one another. Lastly, we're going to move into the management of electronic discovery. I put together the 8 steps in eDiscovery in Texas, which I encounter a lot, but many of these are the same throughout many other jurisdictions, and they're somewhat generic in nature, so that's why they may be fit your particular jurisdiction. First, the party responding to electronic information has to make a specific request for that information and specify the form of production. The responding party must then produce any electronic information that is responsive and reasonably available in the party's ordinary course of business. If the responding party cannot, through all reasonable efforts, retrieve the data or the information requested or produce it in the form requested, the responding party must object on those grounds. The party should make reasonable efforts to resolve the dispute without a court intervention. And if the parties are unable to resolve the dispute, then either party can request a hearing on the objection. The responding party has to demonstrate that the requested information is not reasonably available because of an undue burden or cost. If the trial court determines that the requested information isn't readily available, the court can order production by showing of the requesting party that the benefits of such production outweigh the burdens imposed. And if the benefits are shown to outweigh the burdens, and the trial court orders the production of information that is not readily available, reasonably available, then sensitive information should be protected, and the least intrusive means should be employed. the requesting party must also pay the reasonable expenses of these extraordinary steps required to retrieve the information they want. And last, when determining the means by which the sources should be searched and information produced, direct access to another party's electronic storage devices is discouraged. Courts should be extremely cautious to guard against undue intrusion. So, that said, think about the anticipated results when drafting discovery requests. First, don't define document in 2 or 3 pages. We've all seen those. Consider the requesting party seeks relevant, non-privileged information in all forms in which it is stored and communicated, period. Second, instead of the phrase any and all, use the term including when examples are required. Third, only use the terms in your document request that you actually defined. Fourth, specify the form clearly. Don't assume that because you asked for native format that is sufficient and explanatory to the opposing party. Fifth, and this is an important one, give options so that you know what to expect. In other words, production smaller than 10 gigs should be submitted on a DVD. Those larger than 10 gigs but smaller than 128 gigs should be produced using a flash drive or external drive. Productions larger than 128 gigs should be produced on an external drive or in a load file, and then specify the type of review platform that you want to use for your review. Last, serve protocol with your discovery. Give the opposing party a roadmap of what you need and how best to get there, such as produce delimited load files supplying relevant system metadata field values for each information item by Bates number. Pretty specific. Often a digital forensic expert, or what we refer to as a DFE, is necessary in a complex eDiscovery process. Like any successful project, planning is key, and in my opinion, it's the most important stage of the project lifecycle. As a paralegal and an eDiscovery manager, you have to understand what information you seek, where the responsive information may be stored, how you plan to assimilate the information, process it, and review it, and consider all deadlines and budget constraints. The collection preservation stage is next. With a plan, the paralegal is able to guide the vendor in accessing and targeting the data. Processing of the data allows the ESI to be read and displayed within the software. To review the volume, the data can be run through a deduping process, and then searches can be run to test for responsiveness, and then last, subsequently called out. An analysis of data can include a review of metadata. I think everyone probably knows what metadata is, and an interpretation of the documents, including authenticity. The production stage includes the exportation and formatting of the data so that it meets the specific request. And then last, a formal report may be required or expert testimony solicited in order to prove up the digital forensic process and findings. So now I'm going to switch gears just a little bit and introduce what has become industry standard and led to eDiscovery best practices, the Electronic Discovery Reference Model, or EDRM, which I do not claim to be an expert in, but I think it's a really great idea to be familiar with a few of these models. First of all, EDRM is a standard that was designed to improve the system's interoperability and the transfer of ESI between applications involved at any point throughout the discovery process. There have been 2 subset standards launched from the original EDRM project, and that includes EDRM metrics, and what that's intended to provide is a standardized approach and basically an accepted language to measure the full range of eDiscovery activities, and then what is referred to as EDRM XML, designed to facilitate the movement of electronic information from one step in the eDiscovery process to the next, one software program to the next, and then one organization to the next. If you're feeling overwhelmed at this point, don't. These models, they're not meant for memorization, just merely to familiarize yourself with the various EDRM models that are out there. This is the current EDRM reference model. And a good way to familiarize yourself with some of these models is just go to the EDRM site, Google it, look around at some of the images that are online, and you can see the various reference models, and it'll probably start to make sense, especially after you've managed a few of the eDiscovery projects. And this is yet another one. You note this one refers to information management in the blue rectangle on the far left, rather than governance on the prior one. Governance is the standard term that's now being used throughout many of these types of models. And yet another one. This particular EDRM model I included, this is the project management team model. This one depicts the 3 entities that are normally involved in eDiscovery projects. You'll see it refers to the legal team, the law firm project manager, and the lit support team for a law firm, and then so on and so forth. You have 3 key components to it. Some larger projects may have multiple law firms or vendors involved, while there are other projects that may be limited in scope that do not have each of these entities present. So this model would change based on your particular project. Note that each entity does have a project management role, and all project managers have a combined responsibility for overall project success. This is the EDRM metrics cube. This was originally put out in January 2010, and it includes various phases and the metrics of time, volume, and cost, which you can see across the top there. It's now been replaced by this model. This is the new EDRM metrics model, and this one was released in June of 2013. This one depicts the center with the 3 key metric variables of volume, time, and cost you see there in the middle, and then the 7 aspects of work which affect the outcome associated with the elements at the center. So you wonder, what do all these various models and EDRM have to do with being a manager of eDiscovery and a paralegal? Well, these models are available to corporations, law firms, legal departments. They're tools for communicating with and to eDiscovery process stakeholders on how the metrics relate to eDiscovery and how these activities and the information and the outcomes can best be measured. It assists eDiscovery professionals in understanding the various elements, tasks, and activities of projects, and how these things all combine to form the best practices, resources, and funds of a project. Understanding these models can contribute to effective and timely decision-making at all phases of any eDiscovery project, ensuring an efficient use of resources, and also it will help you manage and control both cost and risk to your client. Part of managing any project is ensuring that all steps are taken, and that means the use of a checklist. I know a lot of people just thrive on checklists. Checklists are great. It ensures that nothing is omitted, that you don't forget anything. So this is a checklist that I came up with. Actually, this was something I found through Practical Law. It's pretty good. It's very comprehensive. As to conducting initial discussions on the eDiscovery process, obtaining organizational charts for the periods relevant to your litigation is helpful. Getting a copy of the company's document retention policy so you know what you're up against is a great thing to ask for. Identifying and addressing any imminent spoliation issues. Gaining a detailed understanding of the company's email systems. Determining how other data might be backed up, and if there's legacy systems that might be involved. The second one, the litigation hold, we've already talked about pretty in-depth. Addressing data collection issues, developing a data collection plan, identifying the sources of potentially relevant data, interviewing key custodians of the potentially relevant data, developing a plan on how you're going to go about collecting paper materials, and determining who's going to corral all that data once you receive it. Preparing and interviewing IT staff is an important one. You have to discuss backups with them. Also, determining date formats is a key one. Preparing for a meet and confer. In doing that, you need to be prepared to discuss the relevant facts of the case, any document preservation issues you foresee, the relevant media and technology involved in the collection of the data, and how you plan on processing that data. Establishing how the data will be processed. In doing so, you need to create a keyword list, set date range limits, formulate and test the reliability, obtaining cost estimates and time estimates, confirming load file formats. I'm going to back up one slide. In developing a document review strategy and conducting a review, you need to consider how you're going to go about loading data into the platform, developing a review budget estimate, estimating how long it will take you to get the documents reviewed, determining what your review team will look like, who it will comprise, training that review team on the platform, and finally conducting an intensive review of the data of your custodians for both relevance and privilege. And then obviously, if it's necessary, you're going to have to create a privilege log. And last, preparing to produce the data, you're going to have to determine the priority of data to be produced, and also consider producing the data on a rolling basis rather than all at once. Sometimes biting off a piece of a production is a lot more manageable. Determining the desired production format, what is opposing counsel requested, negotiating with your opposition as to the format, the load file specs, and a timetable for production, and also a timetable for receiving the production. The role of the paralegal in preparing for a meet and confer. I don't know how many of you normally attend a meet and confer or get your attorney prepared, but some of the things that you need to think about are who are the key players, what are the issues, what events and intervals are relevant, and the attorney may have a good grasp on this, but they may not, because a meet and confer will usually occur pretty early on. You need to know who the person's most knowledgeable about the ESI systems are. When did the preservation duties attach? Are there chain of custody needs that need to be met? What metadata might be relevant? What is the entity's backup practice? How will portable devices, such as cloud storage or voicemail, be handled? What email apps does the entity use? And what did they use in the past? What apps are used in the business and what was used in the past? Are there any personal email accounts involved? If so, identify them. And then finally, will single or multi-page TIFFs be used? Will load files need to be accompanied with the actual document images? What is the protocol for Bates numbering, file naming? How will the media and the eDiscovery be produced? How much time is going to be required? And can there be a cost savings realized by using shared vendors or perhaps a central repository? A framework for paralegals in the successful management of eDiscovery includes some pretty non-technical or perhaps some obvious steps. First of all, get involved early on. Choose an eDiscovery partner as soon as possible. The minute that you realize that this is beyond your resources and capability, you need to meet and get bids and hire your partner. Discuss all procedural rules with the eDiscovery partner and your client. Develop an understanding of your client's IT systems and processes. Cooperate with opposing counsel. Set some fair ground rules. And this may mean going back to your agreement that you've entered. Determine the methodologies and technologies. And document, obviously, all agreements between the litigants. The best way to prepare for ESI is to gather knowledge at the earliest stage of litigation. Another useful tool in managing eDiscovery is what we call a data map. Creating a data map as soon as litigation strikes can really ease the potential burden of an eDiscovery project. What a data map is it's a document or series of documents that identifies the who, what, and the where of the ESI held by an organization. An effective data map can include both traditional and new sources of ESI. So you kind of have to think outside of the box to make sure that you get everything available because a client may not have that knowledge. Without a paralegal doing due diligence to discover what types of ESI exist, again, some of the data types might be unknown and unrecognizable even from an IT perspective. So keep this in mind when you're dealing with in-house IT folks. However, a savvy eDiscovery paralegal will immediately recognize and think to ask about these potential sources and also identify them as both inclusive and critical to your eDiscovery. There are 3 points to consider when beginning to address the processing of any ESI. First, you need to assess the scope of the project. On every occasion that I get a DVD, a flash drive, or an external drive, I open it to see the types of data included and the size. Both of these are important in evaluating how you're going to process the ESI. And keep in mind, you don't want to begin opening up all of the documents themselves because doing so can alter the metadata. You need to consider your options in the design and implementation. And then also keep in mind your ESI always must be handled in a forensically sound manner, and it either needs to support the rules, the meet and confer, or in the event of a non-party, a subpoena. Here's a few pointers in evaluating the processing of ESI that I came up with. Our rule of thumb here at Strasburger is outsourcing data over 2 gigs. Outsourcing any odd type of data such as CAD drawings, x-rays, those type of things. And also, despite what an attorney may tell you, hand you a DVD or a flash drive and say, oh, it just contains a few emails, keep in mind that PST files are usually compressed. And just as your car mirror, what does it say? Objects may be larger than they appear. Emails are larger than they initially appear. So watch out for PST files. More guidelines. Parents can be separate from attachments, but they should be kept together as a family. Preserve all the metadata, particularly dates. And then documents can be in any image format, PDF, TIFF, etc., for Bates numbering or redaction, but not native documents. So if you're looking to Bates number or redact documents, those native documents are going to need to be converted first. And when we talk about native production, we want to use the Bates number as the file name. You're also able to add designations such as confidential, attorney's eyes only, that type of thing. And maintain the production sets either in a database, or you can burn a copy of the production to a DVD or an external drive for providing to counsel. There's 8 steps to keep in mind for when an attorney and a client says, we can't afford this. 8 steps to lowering eDiscovery review costs. Limited eDiscovery scope means reducing the volume of the data that you need to collect, process, review, or produce. And an efficient review team equals potential savings on review costs. You can also cull to reduce the amount of data before the review begins and while in the review tool. And then last, high-performance systems support faster reviews. Increased reviewer efficiency equates to faster reviews. Providing effective training can avoid surprises, mistakes, and improve the quality of a review. Identifying poor performers in the review process can improve quality and accelerate review rates. And those are pretty easy to identify. Someone who can get through a certain number of documents in an hour versus someone else who takes 4 times as long. And last, improved practices and processes will yield long-term efficiencies. Someone once said that you can't manage what you can't measure, monitor, or manipulate. And this is true for management of eDiscovery or any other projects that you manage. If you think about it, managing an eDiscovery project effectively means being able to apply metrics to measure, to monitor the progress of the project, and once you have the data, to be able to manipulate it to suit your needs. So lastly, a few brief takeaways from today that are hopefully will assist you, the paralegal, in the effective management of eDiscovery. Be the single point of contact and the manager for the eDiscovery portion of your cases. Next, take ownership of your project and be proactive, regardless if portions of the project have been delegated or not. Paralegals are better suited than attorneys to eDiscovery. Paralegals are the constant in the eDiscovery process and usually the front line of defense. Associates can move up or tend to move on, and as their level of experience changes, their responsibilities change. Our role is the same. Paralegals guide the ship. As paralegal, as manager and paralegal, maintain logs, tasks, and activity lists. QC every production for content, base range, format, data received, data destination, and unitization. It sounds like a lot to monitor and keep up with, but having this knowledge makes you the manager of the knowledge for your case. Also, keep your eDiscovery partner apprised of upcoming productions as far in advance as possible. Let them know what's coming down the pike. Effectively communicate all of the specs and the statement of works for every engagement to your team. And then again, finally, serve as a director of knowledge, implementing some case management strategies that we've discussed, and being intimately familiar with the scope of every project that you take on. It will just make the attorney look good. It'll make you look more efficient, and you become the point person and basically someone that's indispensable in the eDiscovery process.
Linda, this was an absolutely amazing presentation with so much information. we have a really, really good question. It has some length to it, but it's a phenomenal one. A sincere question and advice desperately sought. Your exceptional credentials define mastery. However, the reality of most paralegals are not adept in electronic files, storage, or infrastructure at client site. What suggestions do you provide when there are no requirements or incentives to get paralegals on board and the issue is not on management's radar? Costs are key, so vendor gouging inept paralegals only exacerbates the issues regarding client fees for vendors and professional services time entered internally. I wholly agree that paralegals should manage what you've stated during the presentation, as well as an adept understanding of the review tools. The reality is what it is. So understanding what he's saying here, we had a very similar question about maybe additional training, or certainly you have no shortage of certifications, maybe going through the Certified eDiscovery Specialist training, for example. What are your thoughts, Linda?
The first thing that occurred to me was taking initiative and reaching out to whatever resources you have available to you to educate yourself in eDiscovery. This was a tough presentation because, as I told Robin, I wasn't quite sure of my audience. I will tell you there are several different scenarios. I know that there are paralegals who work for 1, 2, 3-man shops who may get something along the lines of electronic data and they don't know where to begin. And then you have the mid-sized firm, perhaps a national firm, like mine, that has a practice support group, if you will. And they are the liaison between the paralegal and the vendor. And then you have the in-house paralegal, who basically is thrown to the wolves, and they're responsible for all of this that I just suggested in my presentation. And they're working in-house either alone or perhaps with outside counsel to identify custodians, interview them, gather the data, work with IT, and then determine how best to get that data to their law firm or to be handled in-house. And sometimes that is when the eDiscovery partner comes in. A vendor can help you, if nothing else, by giving you suggestions, ideas, a cost estimate, or perhaps working with you on an hourly basis to at least identify the data and let you know how much it's going to cost a corporation, or if you're with a law firm, what the steps are going to be involved. Most vendors will tell you this can be done in-house if you go this route. This can't possibly be done in-house regardless of all of the resources you may have. This is something that's got to be outsourced because it will eat your lunch. So I think, first of all, to reach out and get the knowledge that you need to be able to know when you need an eDiscovery partner and when you're able to handle it on your own. And if you're working and you feel like you have resistance from attorneys, I think the more knowledge you have, the better, and you can go in and intelligently talk to them and explain to them that they're reaching for the sun, the moon, and the stars, and you'll have to have somebody partner with you to get the information. And with that same knowledge, on the flip side, won't they be impressed when you have the knowledge to be able to handle it yourself, or with a vendor on an hourly basis, which may be very nominal, just to guide you and offer you suggestions? So I think the reaching out, taking the initiative, and getting some additional knowledge may help. For those of you also who may be certified paralegals, NALA now offers advanced certification in different areas, and one of them is in fact in eDiscovery, and I'm going through that right now. And I just wanted to do it for my own knowledge, just to see if I know what I think I need to know.
Would we find out more about that on NALA's site? Is this a new test for NALA, as you shared?
They have been developing the ACP program. They have had one in place for, probably 30 years. But most recently, they've gone to a self-study online program. And they actually, it's available only to CPs. So after you complete the modules in a particular area, you would be an ACP. And they've had the eDiscovery modules and the ACP specialist exam offered in eDiscovery for about 1.5 years now. So for those of you who are CPs, I would encourage you to go through the eDiscovery certification, or the certification that Robin mentioned is also a very good one.
Yeah, just to give a word about that, thank you, Linda. It's the CEDS, the Certified eDiscovery Specialist, and ACEDS has information about that on their website. It's a Prometric proctored examination for those of you looking for information. I'll send out in the thank you notes, we'll send out links to the site Linda has mentioned, as well as some of the others. And Linda, we are at the top of the hour. I want to thank everyone on the call for tuning in to an absolutely phenomenal program today by Linda. We appreciate her expertise and her valuable time. And Linda, thank you for being a part of our Knowledge Leadership Series.
You're very welcome. Thank you, everyone, for joining us.
Bye, everyone. See you next month.